Okay, for Chapter 17, we're going to talk about law and the courts, and we'll be getting into a few more specifics about the U.S. system of federal courts as well as state courts comparison. So let's talk first of all about the general sources of law. In most democratic countries, you have some form of a constitution that lays down the foundation of the law. This is at the federal and state level. Each state has its own constitution, but the federal constitution, the U.S. Constitution, is the supreme law of the land, and that actually lays out the rules of how to make the rules, so to speak. So the Constitution is considered the bedrock of your system of law. Statutes are the legislation that is created by U.S. Congress and state legislatures. There's different areas of domain and jurisdiction with these two levels. The Constitution, of course, delegates a lot of things down to the states. In fact, the 10th Amendment, as we've talked about before, says that everything that is not specifically mentioned in the Constitution for the federal government to do then is delegated down to the states. But the U.S. Congress typically attacks situations that need national attention. Obviously, if there's local issues or state-specific issues, they may not necessarily get national attention until they become important enough to perhaps need some sort of jurisdiction over the entire United States population. We're also looking at things like job safety, minimum wage, pension funds. As I've said before, the U.S. congressional legislation preempts state law. State legislatures are looking at more local matters for that state, and often laws that are going to be passed down through to counties and city governments, landlord-tenant rights, family relationships, things like that. So those are under the title of statutes. Regulations are what the administrative agencies work on. As I talked about earlier, just last chapter, when we talked about the rulemaking process of the administrative agencies and the bureaucracy, very powerful aspect of our government, to where the administrative agencies are making rules, making regulations that we have to abide by. And these are published in the Federal Register on a daily basis, and state rules and regulations, for example, are published in the New Jersey Register. It goes through a long process in order to get a rule or a regulation that has been approved by government. You start off with the notices. We have meetings coming up. We have the announcement as far as some situation that needs to be addressed. And then eventually you'll come out with some proposed rules, and there will be a comment period on those rules where people get to, particularly people who are very much paying attention to this proposed rule as it might affect their livelihood. Then they'll have a period to make comments, and the administrative agency has to respond to those comments and use those comments as a kind of a formative period in order to establish the final rules that we have to abide by. So those all under the process or the title of regulations, both at the federal and state level. Ordinances are typically what are passed by cities and towns in their city councils and commissioners meetings and school board meetings, things like that. You're looking primarily at things like zoning regulations as to what part of your city you want your residential area versus your industrial area, things like that. Building codes as far as what's required for owners to provide safety measures, rent control laws, things like that. So those are the basic sources of law as we go from the Constitution on down to the city and town level. Now, case law is considered the type of law that courts and administrative agencies enact, so to speak, in their rulings. For example, if a court makes a ruling, then all the courts that are below the jurisdiction of that court have to abide by that ruling. So this is how courts have accumulated a lot of power over the years, is that whenever they rule on some decision, then that sets a precedent. So that's what case law is when these court decisions are used as a precedent to decide future cases. Generally, lower courts have to abide by an upper court's ruling. And that's what we'll talk about here in a minute as far as the appellate courts, which are the ones that are above the original jurisdiction courts or the lower trial courts. They have precedent that's set that the lower courts have to abide by. So that's we'll talk about this more in a little bit more detail, particularly under the concept of judicial review, as how higher courts have accumulated quite a bit of power in lawmaking, so to speak, is because their rulings are treated as law that we have to abide by. The only way they could be overcome is that if Congress went back and convened and made a new law that superseded that. But if somebody files a case to a court accepts that case and rules on it, they could potentially strike down something as unconstitutional. And that's what we'll talk about here in a minute as judicial review. So let's talk about the basic types of law. Criminal laws are the ones where they're presiding over some act that hurts other people, bodily harm, property damage, inflicting harm on the interest of the community. And as we'll see here in a minute, the overwhelming number of criminal laws are under the jurisdiction of the state. Civil law is looking at private disputes between individuals, to where somebody has felt like that there's been some sort of wrongdoing to them that's not necessarily a criminal act, or that bodily harm has been inflicted, but that somebody did not own up to their end of the bargain, or somebody did me wrong. So we have two basic types of civil law, and those are contracts, to where we make an agreement, commercial dealings, landlord-tenant, lease agreements, liability, where people are responsible for damages, things like child support. If you sign a contract and somebody does not hold up their end of the bargains, it could go to court, and that's civil law. Torts is where we're looking at some personal injury or negligence. Somebody may have been injured as a result of some company's unsafe practices or carelessness. There's a lot of debate over torts reform, in that, yes, there may be some amount of people that are abusing that system to where they can file false claims against a company or a corporation that's got a lot of money, therefore try to perhaps get some money falsely. But of course, on the other side of the coin, we still have to have a system to where people are protected against damages from a large corporation or from accidents, because of no fault of your own. One of the more famous cases, of course, was the spilling of the hot coffee at McDonald's, where the plaintiff had third-degree burns as a result of the hot coffee. Initially wanted McDonald's to just pay for her medical expenses. McDonald's, which had had a history of several complaints, this is back in the early 90s, and I can attest to this personally. I can remember how hot McDonald's coffee was. They acknowledged that they kept it considerably hotter than most of their other competitors. So they had a company policy of just ignoring the complaints. Well, she took it all the way to the courts, and the courts awarded her almost $500,000 worth of damages. The judge lowered that damage somewhat because she was partially responsible for spilling it on herself. But it is a very famous example of a case where someone was harmed. The company did not really acknowledge that harm, took it to the court, and got compensated for it. Constitutional law is typically what the federal courts are dealing with. some infractions in the political process or violation of rights of individuals or something that's not consistent with the Constitution. And as we see with a lot of Supreme Court cases, they are dealing in many cases with something to where somebody's rights have been violated, whether it's equal protection of the law or illegal searches and seizures or due process of law, that sort of thing. Now, the law is designed to be partially independent of government for a reason. We have three separate branches, obviously. We've got the executive branch that the president is over, and we've got the legislative branch, that Congress, the main piece of that branch by making the laws. And then the third branch of the government is the judicial branch, the court system, which interprets the laws. In order to have a system that's fair and consistent in its dealing with justice, it is somewhat appropriate to have this separation of powers and some amount of independence. So our system of law has evolved over time, still evolving, particularly on the international scale, which we would talk about in another class in quite a bit more detail. People who are trained in law are trained in special schools in order to be experts at dealing with the law. The judge is considered a neutral arbiter. Obviously judges are human and may have some of their own biases, but generally it's set up that they are there to be a neutral arbiter of the case. Part of this independence is so that we can protect individuals from disproportionate power of government. This is something that's been designed in our system. These separation of powers and these checks and balances are there specifically so government does not get too powerful, inflicts the rights of the individual. So the law is there to give the individual a say in that. And of course, in any court of law, if the government is bringing the charges, for example, if it's a criminal case, the police arrest somebody, they gather the evidence, the district attorney then builds the case, and then they take them to trial. The district attorney is representing the government, the state of so-and-so, against this person who has allegedly committed a crime. The government has the burden of proof beyond a reasonable doubt in these criminal cases. So that provides an element of independence and consistency in dispensing of justice. And then we've talked a little bit about the concept of habeas corpus, where people have the right to the due process of law. They have the right to be told what they're charged with and to get before a judge to plead their case and to bring witnesses and have representation and all that. So the habeas corpus is part of this partially independent system of justice. Now the courts, as they were designed, we can go all the way back to the Constitution of the United States, where they initially set up the court systems, particularly in Article 3 of the Constitution. And as you may recall, when we did our quick reading of the Constitution, that Article 3 is fairly short, fairly concise. They considered the third branch of government somewhat the least dangerous branch, but in that a lot of it was subject to be formed by Congress. And as part of their separations of power, the court system interprets the law. Now, they have garnered a little bit more power with this interpretation of law through this concept of judicial review that we'll talk about, that can really strike down a law as unconstitutional. And then, so what that means is that the Supreme Court is somewhat of a policy-making role there. Now, the Supreme Court, as I said before, sets precedents with these rulings of case law, but the court cannot enforce its decisions. A court has to rule on decisions that are brought before it. So that's why we have to have the executive branch with their police force and our system of justice to enforce these decisions. The judges, particularly in the United States system, were appointed by the president. That was the original idea. That's how they still are. They're appointed for life. It was called in terms of good behavior. As long as they behaved, they had the job for life. The purpose of this was to insulate judges from the political process, so they did not have to run for re-election, so that they did not have to proclaim an affiliation to a party or to be loyal to a party. Now, of course, a lot of judges at the state level do run for election. There doesn't seem to be a significant difference in the quality of judges, whether or not you elect them or appoint them. The original idea, of course, for the constitutional framers was to keep the judges out of that political process where they did not have to raise funds to get reelected, because that could result in conflicts of interest later on down the road if they had a case before them where they had to rule on somebody that had given them a campaign contribution. So that's how they decided to do it. A lot of states, such as New Jersey, also appoint their judges. As I just mentioned, judges are elected in many states. So it's kind of a preference from state to state. Now let's talk about the types of U.S. courts, and then we'll look at the pathway that someone could take through a court system all the way up to the Supreme Court. So what we have, particularly at the state level, are trial courts. These are generally the first court to hear the case, and this is both criminal and civil cases. The overwhelming majority of court cases in the United States are in state trial courts. The first level in the federal system are district courts. We'll look at the map here in a minute, and they are typically handling public law, which includes the constitutional law and the administrative law, where you may have a case against an administrative agency. Now, the appellate courts, these are both on the federal and the state level. These hear the appeals of the trial courts and the district courts. Hence, the word appeal is where we get appellate courts. And as far as in the federal court system, about 20% of the federal district court cases are typically accepted to be heard by the appellate courts. And we'll look at that flow chart here in a minute. The Supreme Courts, there are both Supreme Courts at the federal and state level. Now, obviously, the U.S. Federal Supreme Court is the Supreme Court that all the other states, all the state Supreme Courts have to comply with. But in the vast majority of cases that reach the state Supreme Court, well, that's the final authority in that state, and all the other courts in that state have to comply with that state Supreme Court's ruling. And, of course, the Supreme Court is typically an appellate function as well, that you work your way up the court system. If you have a case that attorneys are willing to pursue and courts are willing to accept, you can go up through the appeals court system. Here is the federal court boundaries. What I'm going to show you here is the dotted lines first. These dotted lines represent the federal district court boundaries. So as you can see, there's several of these dotted lines that are showing boundaries of courts. Now, obviously, Kansas is one particular district court boundary. Wyoming, one particular district court boundary. Over here, as we get further into the east, we see Ohio is broken up into a couple of district courts there. Pennsylvania broken up into 3 or 4 there. So what we have is 94 district courts spread out around the United States. Now, we also have 11 Circuit Court of Appeals, and that's these 11 blocks that you see right here. For example, a large chunk of the western United States is under the jurisdiction of the 9th Circuit Court of Appeals. So if ever a district here in Washington files an appeal, it would go to the 9th Circuit Court of Appeals, and whatever that Circuit Court of Appeals rules, every court in this entire circuit right here has to comply with that decision. As you can see right here, the 5th Circuit Court of Appeals takes up the entire state of Texas, Louisiana, and Mississippi. Now, another thing to keep in mind is that in addition to these 11 Circuit Court of Appeal regions, we have 2 additional appeals courts. And both of those are located in the Washington region, which is, of course, the heart of government. So you've got a lot more activity going there legally with respect to federal law. So therefore, you have a D.C. Court of Appeals in Washington, and you also have a federal court of appeals in Washington. That's where a lot of federal court cases are filed or appealed to, because that's where the seat of government is. But if you have a district court out here in one of these regions and you did not like the ruling that you got at a district court, for example, right here, and you filed an appeal, it would go right here to the 10th Circuit Court of Appeals. And then, of course, if you didn't like that ruling and you had an attorney that was willing to try to take it to the Supreme Court, it could potentially get selected to the Supreme Court. Still pretty unlikely, as we'll see here in a minute. Now let's talk about the two-tier court system. And this is in both state and federal courts. Very broad, very generally, what we have is original jurisdiction, which typically includes the trial courts, criminal and civil. And then if you want to go higher than that, then you would go to the appellate jurisdiction, which includes the state appellate courts and the federal appeals courts. So that's, as we'll see when we look at the federal and state systems, that every system is generally structured in a two-tier court system, where you have original jurisdiction, which means that's where the case is originally filed, and then the appellate jurisdiction that is accepting an appeal from a lower court. So that's very generally what that means. Now let's take a look at the path that somebody would take if they wanted to go all the way to the Supreme Court. So what we have here is the federal court path. As I said before, we're looking at typically constitutional law, public law, laws having to do with administrative agencies, treaties, and courts of international trade, things like that. And as we saw on that map, we've got 94 federal district courts with 678 judges spread out over those 94 districts. All of these judges are appointed by the president, and they're appointed for life. So therefore, the president doesn't have to appoint them every time he's elected. There's a lot of judges that will maintain their job all the way through the next presidency. But whenever one of these judges becomes vacant, then a president will appoint one to fill that vacancy. So what we have here is the U.S. District Court is the original jurisdiction. Then we go up the chain. If you want to appeal a district court decision, then you would go, as I showed you on that map, to the U.S. Circuit Court of Appeals. And as you will recall, there was 13 of those courts. We had 11 regions, as well as the 2 additional courts in Washington, D.C. And those 13 courts are manned, so to speak, by 179 judges. And what's interesting about the U.S. Circuit Court of Appeals is that they are presided over by 3-judge panels. So every case is presided over by a panel of 3 judges who are appointed by the president. So they have to deliberate and rule, however that case is decided. It has to be either a 2-1 or a 3-0 vote by those 3 judges for that ruling. Now, of course, if you want to appeal your circuit court, you've got an attorney willing to take that case and appeal to the U.S. Supreme Court, then your case could potentially get accepted. As we have seen historically, only about 1% of all the cases that are appealed to the U.S. Supreme Court, only about 1% of them ever make it. And that's about 1% out of about 8,000 attempts to make it to the Supreme Court. And they only have room for about 75 to 80 cases per year. So that shows you how powerful these circuit courts of appeals judges are, because that ruling is going to stand the overwhelming majority of time. And then very rarely, or it's a long shot. And as we'll see here in a minute, some of these cases are accepted by the Supreme Court for political reasons, which is giving them a little bit more political power that may not have been intended by the framers of our Constitution. And that's what we're going to talk about here in a minute when we wrap up this chapter. But that's the federal court path all the way up to the Supreme Court. Now let's look at the state court path. Now, as I said before, the vast majority, almost 99% of all cases in the United States are at the state trial courts level, both criminal and civil. So if you lose that case and you want to appeal it, you can go to the state appellate courts. We'll look at a few examples here in a minute of their appellate systems. And then if you don't like that ruling and you're able to take it and get accepted by the state Supreme Court, and as we see, the state Supreme Court rulings generally are final because, as I said, if you want to take it from the state Supreme Court to the U.S. Supreme Court, it's a long shot to get accepted. But however, the Supreme Court may reach out and grab one of these cases for political reasons. In a typically perhaps conservative-leaning court, which we do see right now generally, is that they typically lean towards states' rights if they do accept a case that has been ruled on by the state Supreme Court. We've seen historically that they tend to rule in favor of what that state Supreme Court wanted. Not always, but generally have leaned towards that. But that's your path from the state court system, and then you can actually make that leap from the state Supreme Court to the U.S. Supreme Court if all the forces align. Now let's look at some examples. Here's the New Jersey, the state court system of New Jersey. Down here you've got municipal courts, and there's 529 of those courts. We do know that there's 21 counties in New Jersey, so 21 of these are multi-municipal, which are probably county level. Also have some tax courts. And then this bottom layer here that's got the lighter shade of border here, this is your original jurisdiction section down here. People can literally appeal from municipal court up to superior court, but generally this is your original jurisdiction down here. This is called the superior court. Again, 21 counties, 15 courts in 21 counties. And then up here we have the appellate section of the New Jersey courts. As we've said before, we have a two-tier court system. And so here's the appellate jurisdiction tier. Up here we have the appellate division of superior courts in New Jersey. And then we have the Supreme Court of New Jersey, which has 7 justices sitting in bank. So all 7 rule on each case, somewhat similar to the U.S. Supreme Court. All 9 judges sit in mass and rule on that one case at a time. And in New Jersey, Supreme Court justices are appointed by the governor. And one interesting difference in New Jersey is that there's a mandatory retirement age of 70 for New Jersey Supreme Court justices, whereas federal Supreme Court justices are there for life. So there's an example of New Jersey's state court system. New York, as you can see, quite a bit more complicated because the metropolis of New York, you've got several courts down here that apply specifically to New York, but you've also got town and village justice courts. You've got surrogate courts, which are looking at probate cases, will cases, estates, adoption cases, things like that. Family court, several different types of courts, all here that are under the original jurisdiction. County courts, Supreme Courts. And as you can see here, these are the cases that they take. Almost all the courts, unless you're very much of a specialty court, such as a tax court or a surrogate court, as you can see, most of these courts have quite a wide variety of cases that they listen to. And then if you want to appeal, then you go up here to the appellate jurisdiction up here in the upper tier. And the New York has got appellate divisions of Supreme Court, appellate terms of Supreme Court. And interestingly enough, New York's highest court is not called the state Supreme Court. It's actually called the New York Court of Appeals, but that is their highest court. Again, they also have 7 judges that sit in one bank there to decide their cases. Looking at Texas, a little bit more simpler than New York, but you have your municipal courts down here, your justice of the peace courts down here. You've got county courts here, probate courts, county court at law, and then you also have district courts and criminal district courts. These are all in the original jurisdiction section of the state of Texas. And then if you want to appeal, then you would go up here to the appellate division, and what they have in the appellate section up here is the Court of Appeals. There's 14 of those in the state of Texas, and Texas is somewhat unique in that they actually have two final courts. They have a court that's actually called the Supreme Court, and they also have another court that's equally as final as that Supreme Court, and they call it the Court of Criminal Appeals. So what they may be doing here is separating some different types of cases into the Court of Criminal Appeals as opposed to perhaps a Supreme Court over civil, administrative, and constitutional issues, and then another case here particularly appealing to the death penalty cases and things like that, capital cases. So there's give you some examples of state courts, and they all are similar in that they have original jurisdiction and appellate jurisdiction. Similar types of courts, they're just called different things, but they all handle same types of cases. Now let's talk very briefly about this concept of judicial review, which was, the courts decided this they pretty much gave this power to themselves. The famous 1803 case, Marbury versus Madison, where Justice Marshall ruled that part of the Judiciary Act of 1789 was unconstitutional. And so that was a pretty big deal, even though the case was relatively a minor case. It had to do with an appointment that a government official was not allowed to keep when they changed administrations from the Adams administration to the Jefferson administration. So he took it directly to the Supreme Court, and the Supreme Court ruled against him and said the Supreme Court does not have the power to do this, so this Judiciary Act of 1789 is unconstitutional. At least one section of it was. So that really set a huge precedent to strike down a law as unconstitutional, or they can potentially strike down an executive order by a president. Now, they did not use that very much. In fact, they didn't use it again until 1857 in the very famous Dred Scott decision. But here in the past 20 or so years, the Supreme Court has used it quite liberally, and in fact has been using it almost as a political weapon. So that's one of the concerns with the expansion of power of the Supreme Court. But judicial review gives them the power to overrule acts of the other institutions. 3/4 of the countries around the world have some form of judicial review. Even though we do have a separation of power, it does give a very important function as a referee for that court. And of course, as we go back to what we talked about earlier, it is for the purpose of protecting individuals from some arbitrary use of power. But what we see, because since the judges, particularly in the U.S. federal court system, they're appointed, so they're not necessarily accountable to the citizenry. They're there for life. But what that does is give them somewhat of a little bit more of a leeway or a freedom to make decisions and not have to worry about getting reelected. So there is some benefit to that, to have a body that's able to make that decision and not be held accountable to the citizenry. But, it is somewhat ironic because this is an undemocratic element that is pretty much accepted by our citizens of our country, but yet as the Supreme Court takes on even more and more power to make these rulings that really are policy decisions in some ways, that could get a little bit more scrutinized. So how has the Supreme Court gotten more powerful? Well, it's been given broader discretion. There have been some rulings, or I guess I should say some legislative acts that have given the Supreme Court a little bit more leeway as to accepting cases that they want to accept. They have this, they have a broader understanding of what applies to the Constitution. They also have this writ of certiorari power that enables any 4 judges that agree they can accept that case. They can also rule on issues ahead of the public or on issues that Congress does not want to touch because it may be a sensitive issue, such as desegregation, which is what they did in 1954 when the 1896 Act that made separate but equal the law of the land, they overruled that in 1954 with Brown versus Board of the Education, and so that was well ahead of the public. They also technically they made abortion legal in 1972, 73, well ahead of where any legislative body was going to touch that. So that gives them quite a bit of power to reach out and rule on issues that our lawmaking body is still very skittish about attacking for political reasons. But what we've seen, however, is because the judges have been garnering this power, that political preferences are motivating case selections, and that's giving them more of a political power. And that is something that political scientists would start to try to analyze and scrutinize. Is that what was intended by the framers of the Constitution, for them to actually become yet a political policy-making body with these rulings that they're doing? So this concept of judicial review, where particularly just in the past few decades, the Supreme Court has been using it quite a bit to overrule acts of Congress or to strike down various executive orders that the president enacts. So therefore, they have become somewhat of a lawmaking body with this case law, in addition to the interpretation of law function that was originally intended for them. Expansion of power here, similar to what we talked about under the president, how he's expanded his power over the years. Well, certainly could argue that the Supreme Court has expanded its power over the years as well. The book talks a little bit about Sharia, or Islamic law, as a comparison. Quite controversial in that it is where you're incorporating a religious doctrine as part of the legal system, and particularly in the Islamic states. They're also kind of using it as perhaps a way to fill gaps in the code through tradition and moral sentiments that have been passed down from generation to generation, typically used for aspects of marriage and family, which are, again, very much subject to traditions and customs, things like that. Sharia law is even more starting to clash with modern sensibilities, particularly giving equal rights to women, and that's where you could certainly say that it's somewhat still in the evolving phases. The Sunni versus Shia divide has been a considerable source of conflict with Sharia law. In fact, one of the big differences there is how they may interpret it more strictly than the other one does, and that is at the source of their conflict. And of course, that also kind of translates to their code of law in their system. When it comes to divine inspiration, it's not easily adapted by judges, so that's why it's still kind of in a hybrid phase, so to speak. You have to also kind of massage it to make it work with modern economics. For example, in some cases, like interest on loans is doctrinally prohibited, but worked around in order to conduct business. Much like a constitution, it would be interpreted to emphasize evolving needs. Particularly as we're looking at immigration and refugees and things like that, resistance to outside influences, that will be a constant source of concern and analysis